Okay. So I am really excited, if you haven't met Nerisha, to introduce Nerisha. She is a Legacy Advisory Council member with Cancer Support Community. And we formed this group at CSC during COVID. So that's been a positive thing for us at the center. This is year 2 of our Legacy Advisory group. So we're happy to have Nerisha on board with that, among many other things. Nerisha is a California admitted attorney since June of 2007, quite some time ago now, Nerisha. She also has 6 years of legal experience in South Africa, where she's from. Her focus is on estate planning, trust administration, and probate matters. Her approach to estate planning is to listen, explain, and discuss so she can really carefully understand and tailor all needs. I've personally found Nerisha to be gifted in her explanation. She makes very complicated things very simple and basic to understand. And maybe most importantly for this group, she has a really big heart for our nonprofit, along with many other nonprofits and cancer support community. So Nerisha, without further ado, I'm going to let you run the show and how you'd like to handle questions and conversation.
Very most wonderful introduction. I'm most grateful. If you can ask everyone to put yourself on mute so we don't have any feedback in the background. If you can't hear me at any stage, just wave at me or raise your hand or just unmute yourself and let me know. And we can kind of go from there. Questions? Again, there's the chat box. Libby, if you could keep an eye on the chat, I sometimes just can't do both at the same time. But you can, welcome to put any questions in the chat, or again, you can just unmute yourself and I'll try to answer it there or then, or I will circle back. And so let's go, as they say. So my name is Nerisha Soodehul, and I'm a solo practitioner, estate planning attorney here in San Ramon. As Libby said, I'm born and raised in South Africa, and my virtual background behind me is the skyline of Johannesburg, where I was born. And if you zoomed in, you'd find the place where I lived in. So it makes me happy to have it as a virtual background. And so our topic today is, I have an estate plan, I have a trust, what do I do next? Or is the process over? I've signed the paperwork. Do I file it away, put it in a safety deposit box, hide it under the bed and don't think about it again? What do I do with the estate plan now that you've signed it? So I just wanted to do a quick recap and maybe just set the context for our discussion today. What I'm specifically talking about, or the context is, you've got an estate plan that consists generally in and around this area of a trust, a will, a power of attorney for finances, and your healthcare directive. And those are what I call your 4 big documents in an estate plan. The power of attorney for finances, and if I see you making notes, if I talk too fast, just let me know as well. The power of attorney for finances and the healthcare directive are documents that become operative while you are alive but lack capacity. So the power of attorney for finances, who is authorized to have communications, to have discussions in financial transactions. So transactions that are like a debtor-creditor relationship, PG&E, your mortgage company, credit card company, and then also financial discussions or transactions that relate to assets that you own, which are outside of the trust, which are namely your retirement accounts, life insurance, annuities, and the like. And so that's what your power of attorney controls. Your advanced healthcare directive is your power of attorney for health, who gets to make medical decisions on your behalf if you're not able to make medical decisions yourself, who has access to your medical records, or if you lack capacity as well. So the traditional estate planning documents that we think about when we're thinking about who gets what when somebody passes away is a will and a trust. Now, kind of trusts that I generally prepare and that I see in my practice are what I would call a probate avoidance trust. So what does that mean? So just as a general overview, probate is the court system by which we administer someone's estate. And administration means we gather somebody's estate, we pay the debts that needs to be paid, and whatever is left in the pot at the end of the day gets distributed. That's generally speaking what we mean by administration. So probate is the court administered administration process. And we want to avoid probate because probate is expensive, it's time consuming, and everything that you find at court is open to the public. And how we avoid probate is we create a trust and we move those assets that would go through probate into the trust. And that way, the trust is the document that tells us who gets what. And a very common question that I get is, well, if I have a trust, why do I need a will as well? And the simple answer is, quite honestly, clients don't necessarily always do what we as attorneys ask you to do. That's the first thing. So if I give homework to clients and I say, your job after you have signed the documents is to move the accounts that you have, and I give them a list and I would talk with you about that now, into the trust. I help clients to move your house into the trust. And if you forget to do that piece, the will is the document that I have to go to court with, hopefully avoid a full probate. And I can then ask the court, look, court, I have an asset. It's hanging around outside of the trust. Help me to get it into the trust, because the trust is the document that tells me who gets what. And so the will is a backup document for us as attorneys. It's there to catch anything that is outside of the trust that should be in the trust. And that's why the kind of will that we talk about in this context is called a pour-over will. So that just gives you a little bit of the lay of the land, so to speak. What are the documents that I'm talking about? What is probate? And how does the trust avoid probate? So the key takeaway from that little introduction that I've given you is that if you have an estate plan, you have homework, or hopefully you've done your homework. You have checked and double-checked that all of your accounts that should be in the trust are indeed in the trust. So the question is, what are the accounts that are under the umbrella or in the trust bucket? Judy, I see your question about the healthcare directive. I'll circle back to that in a minute. Libby, if you just keep me honest and make sure I circle back to that question. So what accounts go or belong under the umbrella of the trust? It would be a checking account, a savings account. It would be any of your brokerage accounts, an investment account, those kinds of things. The certificate of deposit, which is your CDs. If you have a safety deposit with a bank, the safety deposit is itself an account, so the safety deposit needs to be moved into the trust as well. I had a client up in Sacramento. I practiced for 6 years up in Sacramento, and I did his trust for him. And he had, I think it was close to 19 or 20 checking accounts. And I asked him, but why do you have so many checking accounts? And he said to me, well, honey, you weren't here in the 70s. And I'm like, no, I definitely wasn't in the US in the 70s. That was the time that you got a free toaster for every checking account that you opened up. And he just had, 19 checking accounts. And I thought to myself, he's probably used and doubled all of the free toasters he ever got. But he had all 19 accounts. So it was a very polite suggestion on my part that he considered closing those and consolidating his account. But if he wanted to, indeed, if you have, you could have gone to each of those 19 institutions and moved the accounts into the trust. My hope is that you don't have 19 accounts. So, but there's a funny little story for you. So it's your checking account, your savings accounts, it's any of your brokerage accounts, it's CDs, and a safety deposit box. Those tend to be the normal accounts that we have. And so the accounts that are outside of the trust, and here is your big takeaway, is the accounts that are outside of the trust are retirement accounts, which are a 401k in a 401k, an IRA of any variety. So if it's a traditional IRA, if it is a Roth IRA, if you were self-employed, it would be a SEP IRA. So an IRA of any variety, right? Life insurance, annuities. These are accounts that are non-trust assets. They do not belong to the trust. And that's a very, very key distinction. The accounts that belong to the trust must be, and I'll repeat it, the accounts that belong to the trust must be titled or must be owned by you as trustee of the trust. So in my case, my trust is called, it's my last name, Soodehul, the Soodehul Family Trust. And my checking account would be Nerisha, my name, my husband's name is Prakash, Nerisha and Prakash Soodehul as trustees of the Soodehul Family Trust. So I see a number of questions, and I just want to get through this little piece here. So checking, savings, safety deposit boxes, CDs, investment accounts. You own it as trustee of the trust. And now when you go into banking institutions, I've just given you a nice little phrase, right? But the banking institution has a form, and the form doesn't ask for just one single line, right? They ask, who sets the trust up? Who's the trustee? Who's the beneficiary? And you're like, I don't know. And so here's the answer to those questions. While you're alive, and if you're married, it would be, and you have a joint trust, it would be yourself and your spouse. You are the folks who set up the trust. And the word that would describe you is you would be the settlor, S-E-T-T-L-O-R. You set up the trust. You are the settlor. Another word is grantor, G-R-A-N-T-O-R. You're the grantor. You set up the trust. And again, in my case, only myself and my husband could ever be the people that set up our trust. Right? So when you go in to fill out the paperwork, they ask you, who's the settlor, who's the grantor? It's you. They'll ask you, who is the trustees of the trust? While the two of you are alive, it's you again. You act in the capacity as trustee as well. Ask you, who is the beneficiary of the trust? It's you. You're also the beneficiary of the trust while you are alive. It'll ask you for the name. In my case, the Soodehul Family Trust. Ask you for the date. That's the date that you signed the trust. And those are the key sets of information that they'll ask. Another very common question is they'll ask, does the trust have a taxpayer identification number? No. While you are alive, the taxpayer identification number is your social security number. So you file your tax returns under your social security number. So it does not have, the trust does not have its own independent, self-standing taxpayer ID number. So those are the key takeaways in terms of what assets should be in the trust and how they should be titled. And so Judy's got a question here. Should you have your home in the trust? Yes. So answer back to my introduction. I said to you, the trust that we create is there to avoid probate. Now, there are two trigger factors as to what would trigger a probate. And so in California, if you have a will, if you do not have a will, and here's the important one, so if you have a will, if you do not have a will, and you have assets in value of more than $184,000, you will go through probate. So I'll say that again. If you have a will, if you do not have a will, and if you put this in bold, and you have assets more than $184,000, you will go through probate. So what does that mean, practically speaking? It means in and around this area, if you own your own home, the average values in and around here are going to be about $1 million in value. So if you own your own home, just by me asking you, hey Judy, do you own your own home? Judy says yes. I know Judy is in the world of probate. So I know immediately that we need to create a trust in order to avoid the world of probate. That's why it's imperative that as part of the process, you move the house into the trust. And you do that by creating what we know as a trust transfer deed. And that should be something that your estate planning attorneys prepared for you. But you want to, again, go back to your paperwork and check and double check the houses in the trust. Remember I said to you, the will is only a backup document for us. If there is an asset that's hanging around outside of the trust, I have to use the will and I have to go to court to get that asset into the trust. And that often happens when folks have refinanced their homes. So when you have a refinance, sometimes banks ask people to take the property outside of the trust. And part of the process of refinancing the home would be to ask you to put it back into the trust. And that second piece is where things may have gone wrong. Title companies may have forgotten to put it into the trust. You forgot to tell them you had a trust. Anything could have gone wrong, right? So if you have refinanced, check and double check that your house is indeed in the trust. Does that answer your question, Julie? What else
Philip, Philip had a question. You touched on this a little bit, but if you could expand more on the IRAs, being a really big financial asset that might not be included in a trust, that would be helpful.
Perfect. Philip, before I get to that, Judy's question ahead of you was, when do you, advise to review or revise a healthcare directive? So in general, whether it's the healthcare directive or whether it's any of your estate planning documents, I have a two-part answer to that, because why would I, as an attorney, just tell you one thing, right? So the first thing that I would say to you is, every year that you do your taxes, that February to April timeframe, you're pulling out financial documents, pull out your trust documents, right? And just have a glance through them and see if you see anything yourself that requires a change, right? So I do. Philip, are you asking a question? So just have a glance through the documentation. Check and double check that the people that you want to act as your successors in the trust, that you want to make medical decisions for you in the healthcare directive, Judy, are correct, right? And so, largely speaking, my answer is there some kind of life event for yourself or for the people that you have nominated that would require a change to documentation, right? So has your list of successors, if you nominated your siblings, for example, if you nominated your children, for example, has there been a birth? Has there been a death? Has there been a marriage? Has there been a divorce? Those are the kind of big life events that we generally think of, right? Has there been something that you like, do I want to make a change to this person? So that would give you a starting point. And then two is there anything substantive that you want to change? So in the trust context, do you want to change the distribution? Do you want to change who gets what? And where I often see that the case is where folks want to give specific gifts, particularly to grandchildren, particularly to charities, CSC, for example, or other charities, but where with time we want to make specific gifts in addition to the general distribution. So those would be the kind of triggers or things that should alert you that you want to make a change. But please, if you take nothing away from what I say to you today, write it in big, all caps. Do not, and I'll say it again, do not write on the original documents. You can invalidate the entire document. So I say it again, please do not write on the original documents. If you want to make a note of what you would want to change, make a copy and make notes on the copies. Take a sticky note, take a notepad, write on that, but don't write on the originals. You can invalidate it altogether. And I truly kid you not, I have a case on my desk right now where my decedent, we're opening up a probate because he only had a will. The decedent's brother wants to contest the will. The decedent's brother and himself have an acrimonious relationship. The decedent left his brother $1 in his will, which always makes me feel very uncomfortable when, the gifts of that nature. But the decedent's brother is of the view that the signature on the most recent will is fraudulent, right? And so then we say, okay, if this will is fraudulent, what about the prior will? Is that a good will, so to speak? And guess what? This decedent, when he was thinking about what he'd want to have in the new will, happily made changes and what we call interlineations on the original 2017 will, right? And so this is a problem for us. It could invalidate the 2017 will. If that's the case, then perhaps the brother, if he can say there was fraud, will get something more than $1. And maybe that's his motivation for bringing the will contest. Right? So something to just keep in mind. And I'm sorry, I've probably gone completely off track.
Nerisha, just staying on that though, what if someone has in this group written on their original documentation? What do you do then? And then Philip, I'll get to your question.
Go back to your attorney immediately and have the document re-signed. Right? They will create a new document for you and have it re-signed. But it is imperative that you do that immediately. Right? So go back to your attorney if you've written on the original. So say, for instance, you decided that your distribution is, 3 children, a third, but you want to now make specific gifts. So you want to make a cash gift to CSC, you want to make 4 cash gifts to your grandkids, and you've handwritten that into the document. Go back to your original attorney, your estate planning attorney, and have that document redone. Okay. And I think it was Philip's question about the IRAs, right? So quick recap, certain assets are in the trust and certain assets are not in the trust. Trust assets generally are your house, and at the risk of belaboring the point, checking, savings, CDs, brokerage accounts. Non-trust assets are IRAs of any variety, 401k, life insurance, and annuities. These accounts get distributed by way of beneficiary designation. So you're quite correct. They are not trust assets. And the second key takeaway from today is on an IRA and on a retirement or a 401k, the trust or the trustee of the trust should never be named as a beneficiary. Beneficiaries under retirement accounts should be real, live, living people. Because if you make the trust the beneficiary or the trustee of the trust the beneficiary, there is an adverse tax consequence. The trust has to take the money out from the IRA account, for example, or from the 401k. You get taxed when you make a withdrawal from an IRA or from a 401k, right? The minimum distribution age right now is 72. So if you are receiving distributions from your retirement accounts, if these are what we call pre-tax dollars, meaning when you put it in, you did not pay tax. When you take it out, you pay tax. You're paying tax on your existing tax rate. And I see a couple of folks have joined us. If I could ask you to put yourself on mute with the headset, I get a lot of feedback. I apologize. So you pay tax on the rate you are right now, not the rate you were when you put the money in. So the assumption is that when we retire, or when we hit minimum distribution age, or whatever your age is that you're taking the distributions out, you are going to be at a lower tax bracket than when you put the money in. If the trust is the beneficiary, the trust is going to pay tax at the trust tax rate. The trust tax rate is the highest tax rate. It's close to 40%, which is why you do not want the trust to be your beneficiary. You want a person to be your beneficiary. And the follow-up is, Philip, I see your question. What if your beneficiary is deceased, right? That circles back to what I said to you. When you do your taxes, pull out your binder, pull out your documents. Hopefully within there, you've got a list of your retirement accounts as well. Perhaps you put together a list as well of who your beneficiaries are under your retirement accounts. And that's the wonders of technology. I'm so sorry I got kicked out of Zoom.
Well, I think we're on one of Phil's questions about if you were just touching on if someone is deceased that is listed.
Okay.
And
so if a beneficiary is deceased, right, then like I said, that's a life event that when you are doing a review of your binder, right, your trust binder, your estate planning binder, you should have a list of your retirement accounts as well, and should have a list of who your beneficiaries are under each account, so that will trigger something in your mind that you should talk to your financial advisor, or you should log into your Vanguard, Fidelity, Charles Schwab account and update your beneficiaries, right? So not to get into the weeds too much, so to speak, but say for instance, your beneficiary has passed away and you pass away without making a change, then we would go down to the contingent beneficiaries. And that's why you want to make sure that you have both a primary beneficiary and contingent beneficiaries that are named. Does that answer your question, Phil?
Pretty much, thank you. That was basically it, because my wife and I have each other as the beneficiaries. And I think we have our children as co-secondary beneficiaries, but you always want to contemplate what happens if the most horrible happens, of husband and wife killed in an accident together, or things of that nature. So that's why I was concerned and not clear why. I guess it's for tax purposes. You were saying you can't put it in the trust.
Correct. So say for instance, the scenario happens that you pass away, your wife passes away within a short time, then the distribution would go under the beneficiary designation to the contingent beneficiaries, which would be your children, right? So, and now if we have absolute calamity situation where you and your spouse have passed away, all of the children have passed away, or the set of contingent beneficiaries have all passed away, what happens then? The answer is a retirement account is a contract, right? It's a contract between you and Vanguard. You pay in a certain number of dollars. When you retire, Vanguard pays you back a certain number of dollars. When you pass away, your beneficiaries get the remaining funds within the account. That being said, within the contract rules, so to speak, Vanguard will have their own structure, or what we call order of priority of payment, meaning that if your beneficiary designations fail, or if you just don't nominate beneficiaries, right? Vanguard wants to know who should they pay the money to. So they have a list of who those people are. And so that's the fallback. The final fallback, if everybody is not there, Vanguard will want a probate to be opened so that they can get a court order saying who they should pay their money to. Does that answer?
Thank you very much. That does. We'll have to give that some thought as to what to do. But thank you. That was helpful.
Welcome. Any other questions that I missed, Libby? We answered.
There was a perhaps a listing that Elaine was interested, maybe getting relisted. Elaine, go ahead and pop on if that's the case, and if not, we can keep moving.
Well, there were several. I think I got most of them, the checking, savings, but let me see. There was one something about the IRA 401k annuities as a group, and I think there was something else.
Right. So just to recap, the assets in the trust bucket, right? So trust assets are your house, checking account, savings account, a CD, a safety deposit account, a brokerage account, or your investment account, right?
Okay, thank you.
Those are under the trust bucket or under the trust umbrella.
Okay, thank you.
Non-trust assets are 401ks, IRAs, annuities, and life insurance. So I think, Elaine, the missing one you had was life insurance on the non-trust section.
Right.
So life insurance.
Okay.
Judy?
Back to if someone contests your trust when you die, like the guy that was given $1 and his relatives were contesting it. My trust says that if someone contests it, they're automatically out.
Now that's a difficult, all trusts have what we call a no contest clause within it, and it's a standard clause in trusts, it's a standard clause in wills. However, say for instance, in the scenario that I gave, where the brother is contesting the will, right? If they contest, they get nothing under the will itself. But what happens if the will is no longer valid, right? Then we have to look at what takes the will's place. And what takes the will's place is what we call intestate succession. It's the rules that the law sets up as to who gets what. And what I think in my case right now, the brother is trying to get to, he's trying to get to the point where the will is invalidated. The 2017 will is invalidated, and then he would get money under interstate succession. He would get half of the estate. So you're right. If they contest and the document is found to be effective, then they get nothing under the contest. So what happens if there is fraud found is the bigger picture. Does that answer it, Judy?
Sort of. My attorney had said that if I hand wrote a will, that would be valid, and I could write it, and that says what things I want to go to people, other than everything else is in my trust.
Oh, we'd have to talk offline about exactly how that works, or have a check-in with your attorney about handwriting. I will say to you, I'm not a fan of handwriting things if you have existing documentation. So check in with your attorney before you start handwriting stuff. And again, don't handwrite on the original documents. Anything else that I've missed in terms of questions?
Yes, I have a question.
Sure.
Going back to assets included in the trust, did you say something about a safe deposit box?
Yes. Yes.
Okay,
So-
so that needs to be included.
Correct. Because what folks sometimes don't realize is that a safe deposit box is in actual fact an account, right? the manifestation of that account, instead of it being cash that you deposit into the account, is the box itself, the little box, right? And so the account that holds safe deposit box needs to go into the trust itself.
Okay, yeah. I
I
never-
will, yeah, folks often forget. So that segues very nicely into what my thoughts are on safety deposit boxes. I will tell you that I am not a fan of safety deposit boxes. One, because they are such skinny little things here that you can't hardly fit anything in them, right? And they narrow, they're not.
Hi, Nerisha. Sorry for that.
Oh, and Nerisha's, you can fast forward when Nerisha's internet is cranky. And of course it would be cranky today of all days in this particular lunch hour. So Bill, I was lamenting the fact that safety deposit boxes are thin and skinny and you can hardly fit anything in them. So one, I personally don't think that your estate planning documents should be held or kept, certainly not the originals, should be kept in a safety deposit box. Because we cannot access safety deposit boxes on the weekends or certain Saturdays, early Sundays, and public holidays. And COVID, the pandemic, and closures have taught us, unfortunately, that banks can close branches. Literally, the Wells Fargo that's across the road from me was closed. That particular branch was closed for well over a year here where I am. And there were safety deposit boxes there and clients could not access them, right? They really struggled to access safety deposit boxes. So I am truthfully encouraging clients to close out safety deposit boxes entirely, because you can't even be certain that you can get to the items that you want to keep safe anymore. Because with this bank closure and other bank closures, my branch here actually reopened with time, but we have heard that some institutions closed down branches and didn't notify customers as to what happened with their safety deposit boxes. So the pandemic and hard lockdowns and the like have made me very, very wary of safety deposit boxes. So from an estate planning point of view, I prefer if clients purchase fireproof, waterproof lock boxes. You can buy them off of Amazon. Just make sure that you measure the document size, so you buy the appropriate size. You get them with a key. You can get them with a pin pad as well. And simply put the originals inside the fireproof, waterproof lockbox. My lockbox is stored in my pantry, and you're like, why? And the reason is because my emergency supplies are in our pantry. And the idea is that we would pick up the emergency supplies, pick up the lockbox, and head out the door. Right? It's a fireproof, waterproof lockbox. And that's my suggestion as to where estate planning documents should be stored. That's my preference. I'm not a fan of safety deposit boxes in the day and age that we live in, unfortunately. So I hope that answers your question, Bill.
Question. What if somebody steals the lockbox?
So, and I think that the answer, is similar to what I said before. Go back to your attorney that prepared the documentation, or any other attorney, and get a new original made up for you, right? So you have another original. If you pass away in the interim between the theft and the new original being created, what would happen is the planning attorney would have to certify that a copy is a true and correct version of the original. So I, as a planning attorney, would have to sign a declaration under penalty of perjury that the copy that I am giving to a surviving spouse, for example, is a true and accurate version of the original. And then institutions should be able to take that as the original. The better option is that if there is a theft or, you can't access the safety deposit box because it's gone into somewhere and you can't get hold of it, is to get a new original made up.
Well, I think you're addressing the trust document itself. I'm more concerned about the lockbox.
Well, I'm thinking about the lockbox that has the originals in them.
No, the contents of the lockbox.
Could I offer a perhaps clarifying thought on it? Because I use a safe deposit box myself.
Mhm.
And my concern is not my original trust documents. My attorney has that, but we have title documents, the title to our house, cars, and we have some jewelry. We have things that are, again, wanting to avoid, fire and theft and all, but I assume the risk of fire and theft is less at a bank than at my house. And that's why we use it.
So, it's up to you to decide as to what you think would be appropriate and what items you put into which box, quite frankly. Whether you keep only original estate planning documents in the lockbox, as I suggest, and other items. You always take a risk of theft either way. My thought is just accessibility of original documents. Philip, I will tell you that I don't keep original documents for clients as an estate planning attorney. Some older colleagues of mine do keep original documents. And the reason for that is I could move, the client could move. In my case, I am originally from South Africa. I am going home shortly to visit my family. And I will be out of the country for a month. What if somebody needs an original while I'm physically not here? And so that's for me why I don't keep originals. I don't know if you would feel more comfortable having your originals with you as opposed to having your attorney have the originals. It's a personal choice on my part.
I'm with a larger law firm, so that
ameliorates the issue.
there is not just one attorney involved.
That's good. I give you a perspective, right? So I do want to talk about joint accounts because I often see this with clients where you've signed your trust documents and you've moved some accounts into the trust, but you haven't moved all. Clients tend to keep a checking account outside of the trust, and then they sometimes add children, plural, onto an account. And I want to encourage you not to do that. Right? So when you create a trust, the point and purpose of the trust, besides avoiding probate, is to have a single process of administration so that the trust is the only entity or the only vehicle through which we are going to administer your estate when you pass away. When you have joint accounts, you have now the trust process, and then you have the process that has to take place under the joint account as well, if it's not under the trust. When you have a joint account, there are two types of joint accounts that you can have. You can have a joint account where the child is merely a signatory on the account. So they only have signing authority on an account. They're not necessarily a co-owner. Or you could have an account where a child or anybody else is a co-owner on the account. If a child is a signatory only, if you pass away, then I have an account that's hanging around outside of the trust, and I now have to figure out what means do I use as an attorney to get that account back into the trust, right? Because we want everything to be under the trust umbrella, because the trust tells me who gets what. So that's the first piece. So you're creating a duality of administration processes. The second piece, though, is if somebody is a joint account holder of an account. When you hold accounts in what's known as joint tenancy, or if you hold it as joint account holders, when one person passes away, the surviving person automatically owns the account, right? It's their money. So now we have the trust, and we assumed the trust had these accounts, plus it had the cash from this other account. And now we potentially have less cash to do the work of the trust itself. But also it leads to, quite honestly, hard feelings and just inconsistency. Because if you only had child A on the account and you have 3 children, child B and child C are gonna go, hello, mom, like, why did you only give child A the money? Where's our third share of that money? And it just leads to a greater likelihood of disputes and animosity and hard feelings. And so if you have a trust, keep everything within the trust bucket. It leads to a more efficient and proficient single process of administration. And on my side, it is 12:56, so I'll wrap up with, on that note. If there are any other questions in the last few minutes of our time, feel free to ask me. Nothing?
I have a question.
Sure.
I have a question. I'm wondering, and very interesting presentation. I learned a lot. Is there something kind of like a handout or something that will be available at the website?
On my website? Or
wherever. I mean, I really, I try to take notes, but I know I missed a lot of stuff. So I'm just wondering, is it possible?
So there is information on my personal website. If you want to have a look at that, there is some information on my personal Yelp page. I don't know if CSC itself has any information. If you have your own estate planning attorney, reach out to your estate planning attorney as well to give you an overview. Libby, I don't know what resources are on the CSC website.
Yeah, I'll quickly add on to that. This is recorded and everyone will get the recording in a couple of weeks once it's edited down. So you can pause and fast forward to the information that's helpful to you. So that's one option. And then secondly, we do add all of the recordings to our website under community conversations.
Okay. Thank you.
Yeah.
Okay.
Nerisha, do you have what is your website?
So my law firm is called Soodehul, which is my last name, SOOD for dog, EEHUL law, Soodehul law. So to be www.soodehul.com.
And I can send an email to everyone with that information as well. I know the chat
That would
box
be
can
great.
be
That would be
tricky.
great.
Yeah. Well, unless there are any more questions, Nerisha, thank you so much for your time. And you had some really enlightening points for me personally. And just a reminder, Nerisha is a part of our Legacy Advisory Council through Cancer Support Community. So she is here as a resource for us at any time. So If you want to get in touch with her, you can email me. I'm the Director of Donor Support at Cancer Support Community. You'll get my email and follow up, so you have it in that way. And thank you all for taking the time to support our efforts in this virtual way. Thank you, Nerisha.
Thanks, Libby. Thanks, Andy. Thank you, everybody, for attending. My apologies again for my spotty internet. Take care then. Have a great day.